Hello and welcome. On behalf of the Law Society of Nunavut, I'm Rebecca Jaremko, and I'm our CLA coordinator. I'm delighted to be presenting this panel today on reconciling relations in an age of Indigenous and Aboriginal rights. And as is the case in Nunavut, because Nunavut is Inuit territory, we don't do land acknowledgements that are done the same way as in the South. So suffice it to say that Nunavut as a territory belongs to the Inuit. And I'm very grateful to all of our presenters for giving of their time and energies. And we have a wonderful panel today. So I wanted to turn it over to them to introduce themselves. So on my screen, I see Darren next, which is completely arbitrary, but I will start there.
Afternoon, everyone. Well, at least it's afternoon where I am in Southern Ontario. My English name is Darren Thomas, while my real name is Yongjase. I'm Onondaga or Seneca Nation. I'm part of the Haudenosaunee. I'm a professor of Indigenous Studies, as well as the senior leader responsible for indigenization at Wilfrid Laurier. Thank you.
I see Renée next.
Thank you, Rebecca. Hi, everyone. Very nice to be here today. My name is Renée Pelletier. I am a lawyer partner at the law firm of Ulpius Clare Townsend, OKT. We are an Indigenous rights law firm. We represent only Indigenous organizations and governments, and my practice focuses on negotiation and litigation of Aboriginal and treaty rights. Very happy to be here today. I've been practicing law about 24 years, and have been very fortunate in that time to work exclusively in this area.
And last but certainly not least, we have Alisha.
Yeah, hello. My name is Alisha Chohan. I'm an Ontario lawyer. I'm not Indigenous by background. I am Indian. I'm Punjabi by background. And a lot of my work that I've done in Indigenous affairs has been in policy and policy reform, just specifically for UNDA pre and post when it received royal assent. So I'm excited to be here. I'm currently also a professor in Indigenous public policy making, and a lot of my focus is on the decolonization of policy reform.
Wonderful. So we have some questions that we have to mobilize this discussion. But again, we wanted this to be relatively flowing. So the first question that I had to start is, when we're talking about Indigenous and Aboriginal rights, how can legal practitioners meaningfully engage with Indigenous legal orders rather than relying solely on Canadian Aboriginal law when working with Indigenous peoples and nations? Not sure who to turn to have answer that first. Renée or Darren?
Yeah, I'll take the first crack at this one. So I think the challenge we always have is fully understanding the history of Canada and the creation of Canada. And when you start looking at and understanding the differing perspectives of Indigenous civilizations and Canadian common law and the legal frameworks that Canada operates under, the general assumption is everything belongs to Canada, where Indigenous peoples believe quite the exact opposite. They haven't surrendered their existence as civilizations. And I think the complications for everyone to try to understand is that's the one thing we've done remarkably well in Canada, is not teach any history of Indigenous peoples. We go back to a little bit of the fur trade and a little bit of 1800s, and that's about it. We don't explore the lives of Indigenous nations who existed here for thousands and thousands of years. And it's in those areas that we really begin to understand how profound the civilizations were and are. because they still maintain and practice these ways of knowing that have guided their civilizations. Everything you imagine of a civilized state in the world was present here and was present for thousands of years. We had laws, governance, healthcare systems, social welfare systems, education systems, everything, arts, music, trade, economies, everything of a civilized state was here, but we don't teach anything about it. So the general assumption by most Canadians is following the dominant narrative of discovery, that there was nothing here, that Indigenous peoples were lost, were primitive, were savage, and uncivilized. And it's that complication that when we're trying to come together in the realization of what we're actually trying to reconcile is the existence of multiple Indigenous nations that have existed across this landmass for thousands of years, and how just because we now have a constitution and it's assumed to be owned by Canada and being advanced, that we're just going to wipe all that away. And I think that's where this is what we're trying to reconcile. How do we get all of those conversations together in a meaningful way?
Thank you. And I think to bridge it over to Renée as someone who works in the Canadian legal context more directly.
Yeah, so thanks for that. And I can't agree with exactly Darren's comments around what reconciliation is supposed to achieve are bang on. I think I hear a lot of people talk about reconciliation and we think reconciliation is achieved by land acknowledgements or by just, having conversation, but it's exactly what Darren has said. It's reconciling the assertion of Crown sovereignty with the fact that Indigenous people were here, not just occupying the land, but had their own systems of governance, right? And that is Indigenous law, right? So in terms of what is the distinction between Indigenous law and Aboriginal law, I am an Aboriginal law practitioner. I'm a Canadian trained lawyer, and I practice the law, Canadian law, as it applies to Indigenous people. My clients, Indigenous communities, have their own Indigenous laws, and I'm not an Indigenous law practitioner, right? Very much view my role as a Canadian law lawyer as trying to make space for them in the Canadian legal system to be self-governing and to exercise their inherent jurisdiction in accordance with their own Indigenous laws. But that is truly, from my perspective, what reconciliation is supposed to be about. It is about reconciling those two distinct legal systems. And maybe I'll just say a little bit about, from my perspective, I think the true way to do that would be to carve out and acknowledge Indigenous people, Indigenous governance as a separate order of government. We're not quite there yet, but maybe I'll say a little bit about where I think Canadian law has made some progress in reconciling Indigenous law, in that it has created space for Indigenous laws, right? And I think that we've done that in a few ways. You think of agreements, for example, you have the Nunavut Agreement, and other agreements that can make space for Indigenous governance. So Nunavut Agreement, as an example, their Inuit decision-making is respected with respect to cultural heritage, right? And so there's an ability for Indigenous governance in accordance with Inuit legal systems to be exercised via that agreement. You had the Bill C-92 child welfare legislation that recognizes self-governance over child welfare. There's an area where through legislation, there's been some space carved out for Indigenous jurisdiction. And then other ways are, if you just look at how Canadian law recognizes Indigenous rights. So Section 35 of the Constitution, protected Aboriginal and treaty rights. And you consider that Aboriginal rights are communally held. Well, if a right is held by the community, there necessarily means, that from my perspective means there needs to be a governance aspect to that. So if a right to hunt is held by the community has the ability to manage that. And so, but from my perspective, there's an Indigenous law component. And you also just look at how Section 35 rights are supposed to be interpreted. And the courts have told us they are interpreted both from common law perspective and also the Indigenous perspective. And so using my right to hunt example, maybe the common law sees that as a right to kill a deer, and the Indigenous perspective might look at it as having a ceremonial component, right? So it incorporates Indigenous law just in the definition from the Indigenous perspective of that right. I feel like I've said enough, so I'll pause there and see maybe whether Darren wants to say more, if Alisha wants to add to that.
No, so I'm just going to speak just on my behalf as someone who's not Indigenous, So I think from my experience working in this field, I think it's created a bit of a challenge, right? Because I, like Renée, also trained in the Aboriginal law component of it, right? But also just not having that dissent in itself has it invited me to have an ability to, go further into it. So I was grateful to have been trained by Indigenous-led organizations throughout all of the work that I did. So my understanding of it has really been honed in from what Indigenous law does look like and should be looking like in practice. But, for many of us who may be practitioners just from the Aboriginal lens, right? I think more onus is owed from their end to really incorporate and reconcile these two subjects, especially when you are dealing with it in like courtrooms or you are dealing with like policy reform or other topics that are coming up. Otherwise, you're not really reconciling and you're not really understanding what the Indigenous voice really is in terms of this, which is the most important piece of reconciliation. I'll let Darren see if he wants to continue.
Yeah, like I'll just pick up on that, Alisha. Thanks. Like I think for many in Canada, I think where they're starting to struggle with is trying to understand, as we're trying to move forward as a country and the demand for more natural resources and development and extractive industries of whatever nature. And you see, without following the proper rights recognition, we see so much civil disobedience. And I think where for many, again, it's such a broad spectrum where I hear from many people, why don't they just get over it? Or these treaties were long ago, or none of those things matter anymore. But we have to look at this. If we're going to try to understand and truly work towards reconciling what reconciliation is, it actually has nothing to do with Indigenous people. Reconciliation is about Canadians reconciling with Canadian history. And we have to understand the nature of their very essence of being Indigenous comes with these complicated Indigenous legal orders and practices and principles that say their expectation is to protect the water, to protect the trees, to be stewards of all of those natural resources, and not for themselves, but for all the generations that are to come. We call this and refer to this as 7-generation philosophy. For my people, the Haudenosaunee, we always talk about the coming phases. We have to talk about and consider our decisions based on those coming phases. And so with that comes that level of tremendous resistance and strength and power, and why Indigenous folks are willing to put their lives on the line for these civil disobedience. And it's not, and again, by and large, from the communities that I've worked with and talked to, as a scholar and as a researcher, many are actually in support of development because they want the same things. They want an economy. They want to have infrastructure. They want housing, water, healthcare, all these basic human dignities. And they do realize that economic development is a path forward if they're going to be truly in a beneficial relationship with proponents. But the process to get there, that's where, as legal experts and practitioners working on behalf of proponents or on behalf of the Crown, that's the kind of conversation you have to have, is to really appreciate and understand what is it that these nations are actually trying to protect, and that's going to come over economic development, right? That is what makes them Indigenous. And every Indigenous nation across this landmass all have very specific laws that frame who they are. So you can't take what you learn in the East Coast and it's going to apply in the West Coast or apply in the prairies or apply in Nunavut. It's such a broad range that as practitioners, wherever you end up in this country we now call Canada, you have to study the nations that are present on those lands.
Well, thank you all for those insightful and interesting answers. And we are at a difficult and challenging and exciting time in Canada's history with the prospect of reconciliation. I have another question to mobilize the conversation. In light of the Kibawek decision, what would meaningful, free, prior, and informed consent, or FPIC, look like, and where do you see FPIC evolving within Canadian law? And it looks like we also have some background here about UNDRIP, so you can engage with that as well in your answers.
Yeah, so maybe I'll speak on UNDRIP, just specifically from a system planning lens, because that's predominantly what my work has been, and I'll let Darren and Renée speak to more, the case law and the community perspective of it. So from my understanding of UNDRIP, right now, apart from BC and Northwest Territories, UNDRIP is really at like a federal system level. And this kind of ties into how Darren and Renée have been speaking about it. But from a system planning sense, right? Like reconciliation is difficult to do just because our entire structure political system is built off of colonial model, right? So I think in that sense, how can reconciliation really happen at a ground level when we're looking at, courtrooms or community engagement and decisions like that, if the top-down approach is still colonially built, right? Like it's really difficult to have just Indigenous advocacy and, courtrooms to really be responsible for the reconciliation process if we are politically not shifting it in terms of, having it at every single aspect of the political structure from both the federal, provincial, territorial standpoint. So in terms of that, that's really how I see like UNDA and UNDRIP, an issue is just coming out with it, playing out. I know that UNDA right now, right, it has a federal action plan that's supposed to be going until 2028, right, in terms of how the consultation and just inception of it is looking. But like, once again, like, I think this goes back to the entire argument that it's not really reconciliation if the timelines for it and aspects of it is still from a Crown perspective, right? If you're looking at an action plan that's 5 years and you have, political mandates that keep shifting, Crown governments that are really responsible for owning in on like what action items are going to be on the table or what the working tables are going to be set up like how can reconciliation really exist if the Indigenous, political groups or advocacy groups that are part of this are responding to it rather than working with the government in terms of setting their own timelines or setting their own, mandates and priorities and fiscal priorities. So I think that's kind of like issues that have come up with UNDA from my experience in terms of it. Just one last thing that I'm just going to touch on just before I pass it on is just, and I'm curious to know what like Renée and like Darren think about this is like the distinctions-based approach, right? I think the distinctions-based model has historically been the model that government has used, right, to really streamline Indigenous peoples into, 3 categories of like Métis, Inuit, First Nations. But once again, like given the diversity of the Indigenous population, right, how it differs so drastically from nation to nation, has jurisdiction provincially, right, even at a community level. And now with like the urban Indigenous population being predominant, Southern Inuit population, non-status, I think it's a difficult action plan to really play out if you are using models like that just specifically to handle UNDA. So that's my take on it, but I'm curious to know what Darren and Renée think about the action plan.
I'll jump in there, Renée, if you don't mind. Yeah, this is pretty loaded. Like we could spend just we could spend a whole afternoon just on this conversation. We are at a very challenging time. I mean, we're witness to so many right-seeking groups and self-identifying groups, and like so many challenging efforts, and people fraudulently claiming identity and taking up space, and whether it's in arts or in universities, and it's everywhere, right? So this is not going to be easily solvable around right-seeking groups. And of course, if you're in Ontario, you're certainly witness to a lot of the challenges with Métis community councils trying to assert rights for historic Métis settlements and seeking more rights, but it's starting to infringe on First Nations rights and territory. So there's conflicts amongst them, but like I said, so before I jump into that rabbit hole, let me go back to the UN Declaration. And the UN Declaration really came from about 70 years of work by different Indigenous peoples going to the League of Nations before we even had the UN. And basically what started happening in the 1970s, they started applying some pressure because they had made stated commitments to the recognition of Indigenous people's rights at that international level. And so although the UN Declaration is the lowest form of any convention or material that comes from the UN, and it's not legally enforceable, it provides us a framework for really where we could go if we were truly going to share power. And I think this is, the principles of FPIC really need to be understood as they were written and fought over in the 10 years of the writing of the UN Declaration. And talking to many of those folks who were present at those meetings and getting that, nobody was happy with the end result, right? The UN Declaration is the lowest form. It's the basement, right? It's not the ceiling. It's not the standard that we're working towards. It's really meant to be a pathway to secure a stronger relationship amongst governments and Indigenous peoples, or proponents and Indigenous peoples. But it's studying those principles of pre, prior, and informed consent is what's going to really allow us a pathway for reconciling. And I think the challenge of enforcement in Canada is, as long as Canada as a Crown authority, whether it's Canada or provincial Crown, territorial Crown authority, if they always wield the power over Indigenous people, we're never going to reconcile anything, right? And, as a people living today who survived the pandemic, we're witness to the power of the Crown when they can put vaccine mandates and masking and all these things that they created. So the Crown can use and exercise that authority for the greater good. And when it comes to resource development, economic development, the question is, whose greater good is in consideration? Is it the people of these Indigenous communities that are so impacted by this economic decision? Or is it the benefactors, the investors, the boards, the employees of these industries that are destroying these ecosystems? And I think this is where, Bob Joseph writes in his book that Canada is in a conflict of interest when they wield the power to decide the actions of economic development over Indigenous people. So we have to find a mechanism to share power and decision-making power, and that's what can come from the free, prior, and informed consent. It creates a pathway to have those critical discourses with one another. So Renée, I'll pass it over to you.
Oh, that's great, Darren. I think I'll pick up on your comments around when UNDRIP came out. that it wasn't a legally enforceable document. And that was exactly right. I remember when it came out, I had clients calling me like, this is great. How do we bring this to court? And at the time it was like, it was an international document, and it was helpful, and it could be used in arguments in courts as something that was persuasive, and it could be an interpretive guide. But at the time, that's exactly it. There wasn't much legal enforceability. But I'd argue that that was supposed to change, right? When Canada implemented it and then came up with the UNDA Act. And so what we're seeing now is like, okay, this is great, but what does that mean? And so in terms of the case law, what the courts have said, I will necessarily just like touch on this at a very high level because Darren, as you say, we could talk about this for an entire afternoon. But we had the Supreme Court of Canada consider UNDRIP in the Bill C-92 reference, talked about the United Declarations on the Rights of Indigenous People as being the positive law in Canada, right? Which would suggest that these are enforceable rights, perhaps rights that you could sue on. And then we've got a few decisions that have been coming out. There's the Kettlewek decision that Rebecca mentioned previously, and there's a case coming out of Alberta that talks about it a little bit differently, right? UNDRIP is helpful, and there's an obligation to consult with respect to UNDRIP, and courts are talking it more as an interpretive aid. And so it's unsettled at the moment, really what UNDRIP means. What I will say, though, is that what we're seeing from the federal government in terms of what it thinks UNDRIP means and what it thinks UNDA means, you look at the example of the Impact Assessment Act, right, which the federal government has held up as an example of how they are implementing UNDRIP into Canadian law. And in that act, there is, if regulations get passed, there's ability for the federal government to, effectively delegate aspects of impact assessment to Indigenous governing bodies. That sounds great, but to Darren's point, right, that like, and to Alisha's point about it being top down, that if effectively the minister is still the one that's making decisions on whether projects go ahead, having an Indigenous governing body do stuff, and perhaps in accordance with their own laws, and that's great. But if they're not ultimately making decisions or truly influencing decisions by giving or withholding consent, right, then I'd argue that that's not really the spirit and intent of what the United Declarations on the Rights of Indigenous People was intended to achieve. And the other thing I want to flag with this is that we spent a lot of time talking about FPIC, and FPIC is, of course, important, but there are many, many other articles in UNDRIP that I think we don't often talk a lot about. One of them is Article 18, which is the right to make decisions in accordance with Indigenous people's own decision-making institutions, right? So when you think about, and we're going to talk about consultation a bit later, but I invite you to remember that, right? When you think about, that any Crown government consulting with bringing Indigenous people into their process, is that really respecting the right of Indigenous people to decision-making in accordance with their own, institutions and systems of governance, right? So we've got, FPIC is great. I don't want to take away from it, but there's a lot more that I think we need to be truly making space for in Canadian law.
Yeah, and something I want to add, right, like that I've seen in practice on working tables, right, that I think Crown partners could really benefit from just, advancing this. So like under working tables are set up in a majority of sectors, right? You have like justice, MMIWG, you have housing, right? There's a lot of sectors that we're looking at. But I think the issue that often comes out is that government, ministries are often like siloed, right? Versus articles written in UNDA, or, even if you're looking at UNDRIP overall, a lot of things, they cannot be siloed as just like one topic specifically, right? So if you're looking at something like, midwifery even, or, health legislation in terms of it, midwifery is just even more than just access to health, right? It's like self-determination. It's like economic development, women get a right to like have roles in economic leadership. You're bringing back like matrilineal practices, right? You're bringing back Indigenous culture. Like there's so much that each one of those articles really presents. And I think the essence of indigeneity gets really taken away when you are siloing some of these topics into like, this is what this ministry is going to focus on, or this is what this ministry is focused on, because they're all interlinked with each other in a very relevant way. That's part of Indigenous culture overall that needs to come back, right? Specifically for it. And so I think I just wanted to mention it that from what I've seen. And I think like another thing just from practice is that, oftentimes, right, like if you have things like MMIWG, there's so much vulnerability on those tables specifically, right, in terms of the trauma aspect of these groups. So if they are going on working tables, right, you have members, right, that family members of the deceased on these working tables that are providing their input on it. I think things like that increase vulnerability of these working groups. And I think in a way, it often does get taken away from work that can be done, because the entire aspect of it really is to build Crown Indigenous relationships first and then be able to do the work later, right? But I think there needs to be a more work done on the trauma-informed practice of putting UNDRIP and UNDA and looking at this legislation top down from a system level, right? To see how can we put reconciliation into the system so it looks better at a ground level when, Renée, you are engaging with it in like a courtroom setting, or Darren's looking at it from a community setting, right? Like it needs to start from the top, just working its way through.
That's great. Well, I just want to chime in out an excellent point, Alisha, about sort of looking at things as a whole. And that's exactly right. I flagged that there are other articles we can't just talk about FPIC, but precisely UNDRIP is intended to be read as a whole, right?
Yeah.
Picking out specific articles. So that's a very important reminder.
Okay, great. So following question. When Indigenous nations and advocates respond to federal legislation like the One Canadian Economy Act that has the potential to fast track major projects without full Indigenous consent, what thoughts would you like to share about how Indigenous nations and advocates might want to respond to this or act in response to it?
Maybe I'll maybe start with just a little bit about what I'm seeing in my practice with a lot of my firm's clients. And the first thing is to pick up on Darren's comments, so his opening remarks around recognizing the difference in Indigenous communities, right? And so I think as a whole, if you look at sort of the pan First Nation Indigenous, response to things like Bill C-5, wasn't necessarily positive. It's an act that allows for the fast tracking mostly of some major projects. But that's not to say that every single Indigenous group is against it, right? And so I know in Nunavut, right, there's been support, and I think that it's important to recognize that different Indigenous communities have different priorities. I know that there's been a commitment that Bill C-5 will work, within the Nunavut Agreement in accordance with modern treaties and will be aligned with that. And so that is great, right? And if that is a way, if communities want to exercise their right to consent to those kinds of things, then they need to be given the space to do so. I think for other communities, some of the fears, of course, if you look at my comments of not just looking at free, prior, and informed consent, but looking at the promises of UNDRIP as a whole, fast tracking a process, even though there have been comments, about consultation will still happen. The federal government still, hopes to achieve First Nation or Indigenous consent. Those things are great, but if it's in a fast tracked process, does that give the ability of communities to make decisions in accordance with their own decision-making institutions, for example? So there's, I think, a lot of concern, right? A lot of concern of perhaps even with the free, prior, and informed consent, the informed part, our community is going to be given enough time to get the information that they need, right? That being said, on the flip side, this I think does has the potential to provide opportunities for communities as well, right? I think the federal government has been clear with Bill C-5 that they very much see they want First Nations and Indigenous groups to be, a part of projects to benefit economically. And so I think some communities are seeing this as something that has the potential for some promise, right? But there are still legal obligations. And that's the other thing just to remind folks of is Canada's obligations with respect to recognizing, respecting Indigenous rights lie upstream of any legislation, right? So you can't legislate away the duty to consult, protection of Indigenous rights. Like those things are obligations that all Crown government have regardless. And so, more will be revealed as this rolls out. But of course, the hope is that this proceeds in a way that still manages to respect all of those rights.
Yeah, communities are already asserting they're not going to allow this to proceed in the manner which it's being pitched and advertised by current government. Um, I said, Renee said it perfectly. We're very much in the level of resistance to protect the rights that are recognized in the Constitution, as well as our inherent rights granted to us by the Creator. So it's using these two things to build up the level of resistance and strength to ensure um, the advancement of Indigenous health and well-being. And then they recognize that. And if we could find a pathway to bring those conversations forward in a manner that is about sharing power. And keep in mind that the key principle of the UN Declaration is the principle of self-determination. Indigenous peoples in Canada have never had the basic human right to be self-determining. And this process, and we know, there's no mystery of why the lands that are currently occupied in Canada remain mineral rich are also Indigenous held lands. If you just look at a map of Canada, where is most of settlement? It's all in the south. Where are most First Nations? All in the north, right? So the comparison that I've been talking about is it's like we're going back to the beaver wars because everyone is fighting over control over the fur trade. And they're saying to Indigenous people, you're kind of in the way. Why don't you go move north and get out of all this fighting and stuff? And so now they're all in the north and they're saying, well, don't you want water? Maybe you should just move south. Abandon those trap lines and move south and move to the city. And then, like I'm not a conspiracy theorist really, but, there's some things that really connect, right? And, to really understand what it's going to take to reconcile such awful historic relations means a lot of hard work, a lot of labor, and it's going to take time. And no matter, even though we're in a really troublesome economic reality right now, we're not going to solve this quickly with the introduction of new legislation because these rights have existed for Indigenous people since the beginning of time. And they're not going to terminate those because it's in the economic interest of Canada.
Yeah, I think just listening to this, like I don't want to add to this, but I just want to add like a different layer to just how products are done, right? I think another thing, as practitioners who may be reading this should be mindful of, right, is like joint ventures, I think is quite a large component, of economic development. And I don't like, I just want to hear like what your opinion is, I guess, from the joint venture perspective, right, Renee? Like in practice, like how do you see like, reconciliation, playing out, especially when you have, like the One Canadian Economy Act, which is helping bolster projects and moving them faster. But at the same time, you may also have another partner/shareholder in the perspective, right, in the development portion of it. Like, do you see it as being a hurdle to this act, or do you like, I don't know, like it's hard for me to envision this in practice really play out, but joint ventures are a huge component, right, of development projects in itself.
Yeah, and so I think it depends on the ability of an Indigenous group to have, say, an equity ownership in some of these projects, right? I think that can be a stand-in for consent, right? That can be a stand, like, you know what, this is going to be great benefits for my community. I'm convinced that like this project can go ahead in an environmentally sustainable way with a way that like, respects and protects rights. And if I'm, if I've got an equity stake, then maybe I have more say. Like there's lots of, I think this could be a positive thing. But here's what needs to be in place is, and I see this in my current practice. my firm, we practice across the country, and it would be no surprise to anyone that like different provincial jurisdictions and territorial jurisdictions, view rights, respect Indigenous rights differently, right? And so I practice in some jurisdictions where communities really feel that they have a choice, right? They can decide to support a project or they can decide not to support a project, and that Crown government will respect that. Versus other jurisdictions that I practice in, where the feeling is this project's just going to go ahead anyway. It doesn't matter what I say. And so I guess I should probably get an impact benefit agreement or, have some kind of partnership, because otherwise I'm just going to lose out. In that situation, that's not a stand-in for consent, right? And so I think it is sort of what I was trying to say before, that this, if it is true that, we hold the federal government to their words, right? That like these projects aren't going to go ahead if communities aren't on board, then that really needs to mean that these things are not going to go ahead unless communities on board. And if communities feel like they really have that ability to say yes or no, then I think that this could be a very positive thing. But what I would hope isn't the case is that communities are feel like they've got to sign up because it's going to go ahead anyway, right? And that's not really recognizing and making space for true self-determination.
Yeah, and I think also like the issue also comes out with just like in practice, right? Just being a federal legislation currently, with all province/territories not currently having it, embedded in the legislation itself. I think it's like, I'll be curious to see how it plays out in practice, right? Just having that disjunct between a federal legislation versus provincial territorial not really acting in the same manner, especially when you have economic development projects going away, which will obviously cause like issues jurisdiction to jurisdictions depending on that.
Maybe I'll just chime in on that, and just to remind folks that this like right to have consent is not restricted and limited to those jurisdictions that have UNDRIP type legislation, right? Canadian law recognizes that when you have Indigenous, Aboriginal rights under Canadian law that have been established, that any Crown government is not allowed to infringe on those unless it can justify the infringement. And that's a really high standard. So as much as, I do think that we need to move away to really making space for Indigenous jurisdiction, even our current framework, the current framework on Section 35 makes space for the ability of communities to say yes or no and to have consent. So I think it's important to remember that it's not just that if you happen to be in a province or a territory where there's legislation implementing UNDRIP, you have more protected rights. Canadian law already is supposed to protect Indigenous rights.
Okay, well, thank you for those interesting, insightful comments. So the last question that I asked previously was assuming an audience of people who are representing Indigenous communities. Another question from another side, for those who are watching and trying to work in this context who are not the Indigenous communities themselves or Indigenous persons, what practical trauma-informed approaches truly strengthen relationships with Indigenous clients and communities, and what common pitfalls should practitioners avoid?
I'll let Darren start. Yeah, please.
Yeah, there's enough critical Indigenous scholarship now that folks need to read. They need to study, I've been in the university for a while now, and in the early days, there was the expectation as an Indigenous scholar that you could meet colleagues and they say, well, tell me about this and help me understand this, But since the early 2000s, a lot of really great critical scholarship has exploded. And we need to understand who the people are that we're trying to work with, and the assertions of power over are never going to advance where we need to go in this country. And folks, let me also tell you, there's an explosion of Indigenous students in post-secondary institutions. We're getting professionals in every single discipline. And, you know, the big joke I made for years was that we're repopulating Canada because we had a higher birth rate than non-Indigenous folks, right? But they're taking up that space and they're being allowed to, you know, we're witness to a phase of community rebuilding, of moving past the trauma and taking up space in a rightful place in Canada and trying to find success, whatever that is for them. If it's within community and community development, or if it's in a broader based society and working across all areas. So we need to understand the social political history if we're going to truly be trauma informed, because we have to understand, you know, like we're living at a really problematic time in the culture of humanity right now. And never imagine that we would be talking about white supremacy in the level that we are witness to it. You know, the fact that, yeah, we have to teach people that being a Nazi is bad. Right? You know, that's ridiculous that we've got to that place in human history again where we can see such devastating results of very poor thinking about humanity. And studying and learning that history isn't about pointing fingers and say, gosh darn Canada, you did this, or you white people did that. It's not about white guilt or making anybody feel bad, but we have to understand the situational context in which lived realities are coming from. And that's the only way. We have to see the humanity in one another, understand why Indigenous communities are so passionate for protecting and stewarding their lands and their rights. And we have, like I said, we're all human. We all want the same things. We want a society, a community where our children can progress, have basic human dignities, and have the right of being self-determining. And the only way we can do that, if you're working with proponents or yourselves don't know anything about Indigenous people, don't know anything about the social political history, read some books and read some and Indigenous scholars. Don't, because there's a lot of non-Indigenous scholars that are still saying Indian residential school was a good thing, right? You can't study that. You have to study it from an Indigenous lens and what we've gone through as a people. If you're going, what we have to construct by learning this is we have to construct empathy. And that's what we're lacking. There's still so much racism directed at Indigenous peoples in this country.
You know, I'll add to that and bang on, Darren, in terms of like take the time to educate yourself and read. And the other thing I might point to is the Truth and Reconciliation Commission report and calls to action, right? I think is something that would be important for people who are, you know, on the Crown or proponent side, sort of coming into community to read. And then just in terms of some like just practical tips, things that I've seen in my practice, you know, recognizing that Indigenous governments, so like a First Nation, for example, the chief and council have so many priorities and like crises going on in their communities. It's just being pulled in every direction. Many communities are under capacity and understaffed. And so, you know, if you're sending an email and you directly to the chief and you haven't received a response in a couple of days, right, don't assume that means the community is not interested in being engaged on your project and then you walk away. You know, just appreciating and understanding what communities are dealing with, right? And I think it's just, that's something that I see often in communities say, or sorry, companies say, well, we tried to get in touch with the chief and we didn't get a message back, so we assume they didn't care, you know? And I just think, God, the amount of things that chiefs in particular are dealing with, you know, I'm surprised they get to any of their emails. So that's something that I think is important to keep in mind.
Yeah, and then I'll chime in as the non-Indigenous panel member. So yeah, so I think from my experience, right, I think this is like many of us, we are all settlers. If you're not Indigenous to this land, you are a settler. And as settlers, we all have our own responsibility towards the reconciliation process. What it means for me, it can look different from everyone else, is that I really try to take the space to understand what Indigenous law really means in practice and how it differs from the Aboriginal law concepts. And as legal practitioners, I think that's something that we really need to work on, especially because given ANDA and given how Indigenous affairs is really forming and developing, it's going to be a field that touches every single sector in a very good way and in a very relevant way, right? Like reconciliation isn't going to disappear. It's going to enhance and it's going to be Indigenous led. So at one point, if you don't do it now, you're going to have to learn to better engage and let Indigenous peoples like really lead the way for self-determination and for what they need in their community. And so it's better, that we all start now and really incorporate it, especially when we may not be versed with it. So, I think the biggest takeaway for me that has been, in my experience is I don't have experience as an Indigenous person to this land. So it's really letting, scholars or academics or people who have that experience to pivot and speak on matters that I only know conceptually. So yeah, I'm hoping that's been working really well for me in terms of it. So I'm curious to know what Darren and Renée, if they want to add anything else to this in terms of it, but those are my piece of advice.
So I'm very critical of the word allyship and the notion of an ally. And I'll tell you why. We've gotten very comfortable with being an ally. And being an ally isn't good enough, right? We can read, we can attend workshop, we can attend a webinar and think we're terribly informed now, right? Where we need to elevate to, if you're truly working in support alongside Indigenous people, is we need accomplices. We need folks that are willing to use their power and privilege in support of liberation, right? And that means when something lands on your desk, what are you going to do with it, right? Can you sweep it away? Or do you have to sink your teeth in and try to help, right? With my job at the university, what I often joke about, I'm responsible for indigenizing a university. It's an impossibility. You can't indigenize something that's inherently non-Indigenous. I cannot decolonize something that's so inherently colonial, but we can make it safer. So when we know that there's deliberate harms, we can try to mitigate for those harms. And the work that I encourage folks to do is to see yourself as a tool for liberation. And that when you're starting to engage community and work with Indigenous organizations, communities, leaders, you don't go with them with a solution. You go as a blank slate and say, these are the tools that I have. Use me if you want. I'm here to support you, right? What I often joke about for myself in my own life, growing up in Haudenosaunee culture, I'm 4 generations removed from Indian residential school, grew up in a strong matriarchal society. I know a lot about feminism. I would never in my life walk into a circle of a women's group and say, I know the answer. I know what you need. I know where my place is. It's in the back of the room with my mouth shut, right? But I also know I have skills that can support the liberation of women. And so that's what I provide. I go into those spaces and this is how I do it. And I'm here if you need me, but I know where my place is, right?
That's a great comparison, Darren. And I love we need more accomplices and less allies. I think that's great. Yeah, I think maybe what I would just add to that is I think even for Indigenous people, like lawyers who are Indigenous practicing Canadian law, I think it's something that is important for folks to remember too, is that it's my comment initially around I'm a Canadian trained lawyer working within the Canadian legal system. And remember, we had at my firm a very young, very bright, sort of eager, free Canadian trained lawyer who came and said, I just really want to practice Indigenous law. And I had to say, I'm really sorry. Perhaps you can practice free law, perhaps you're trained in that way, but like that's not something that we provide. And that's not to say that we can assist our clients, as Darren said, when we're asked, but to just repeat my comments at the beginning, I really feel like my job is to make space, use the tools that I have as a Canadian trained lawyer to make space to push out, push Crown governments out of the way as much as I can, so that my Indigenous clients can practice their own laws. And I can use the tools that I have to assist in that process, but by no means can I go into a community and think just because it's, that I have some exposure, or perhaps it's in my heritage, that I somehow know their laws, right? And that's something that I think is important for people to remember.
Yeah, sorry, one last comment, and I'm being mindful for time. I completely agree with this, right? And I've seen it come up in the classroom when I am teaching this, and I have Indigenous students in the classroom, right? And for me, like what I've been trying to embed into practice is like, hey, look, like I'm not Indigenous. I'm teaching this in the way that I've been taught or I've been doing it, but I'm always mindful of, taking the Indigenous opinion in it because it's relevant and it's the initial opinion that should matter first and foremost. So I think in practice settings, right, if you do have someone, especially in group settings, when you are leading something who happens to be of the descent, it's really important to put their opinion first, because you can only learn so much behind a desk, right? Like the real breadth of the experience does come from having it be lived. And so, yeah, that's my last comment.
I want to thank everyone again for being here and for taking the time to, do this public service for the Law Society of Nunavut, and also for the LexisNexis educational component. And it's been very valuable to have you here. And again, clearly we've just scratched the surface, but I think I'm just very grateful to the commitment of time and the insightful remarks everybody's made. So I think at this point, we're going to have to wrap up. The slides will be available to everyone who's an attendee after the fact. And again, thank you all so much for being here.
Thanks, everyone. Thanks, Rebecca.
Thank you.